Hello everyone, welcome to Property Experts, where we provide you information related to property in a sensible manner. Hence, before purchasing property worth lakhs and crores of rupees, please do watch our videos to never miss any sort of an opportunity and where you can prevent yourself from falling under any sort of a scam or a fraud. Well, today it's time to answer the legal problems that has been asked by few people. The first question that has been asked by a gentleman, like he has a very peculiar problem. He says that he took a loan on a house and that particular house was sold twice by the builder. Now he got to know about that cheating and he complained about it. The builder is behind the bars, but the bank is forcing him to pay the loan. Now he stopped his EMI some time back, but now the bank is building up pressure again and again. What should he do? See, you'll have to bifurcate your problem into two legs. First of all, the builder sold the same flat twice to two people. You need to check that your agreement is in place, which is prior to the other person to whom it was sold, in case that is the issue. Then of course you have already filed a shooting complaint against the builder. He's behind the bars. He should be out in some time, or 6 months, 1 year, maybe. One can pursue that cheating case against the builder and he will have to cough up the amount or give you the flat. As the case may be now coming to the other problem, which is more you know, which requires more consideration at this point of time, that the bank is pressurizing you to repay the home loan or the home loan. So please understand that the banks at this time of granting a home loan do their own sort of an investigation, and due to ignorance or diligence they must have done due diligence regarding this flat. They must have done the diligence and the bank records and the authorities, the cause and everything. So today when you know that the same flat has been twice sold, then how come the bank is not aware of it? I would suggest that you should file a civil and a complaint and a criminal complaint, and which you should make the bank also as a party, saying that you are a bona fide purchaser. The builder do you the work, or the bank is now duping you. How is that they are liable to pay all of this? I am quite sure that the minimum the court will do as an interim relief will be to grant you this much, and that you are not supposed to pay the EMI till the case is decided. Okay, so now let us go and get relief from the Emisan's shoulder. That's a big relief. Let's go ahead to the next question that has been sent by email. He says that he booked the flat in December 2012 and the agreement was signed in 2013. When the builder got permission from the authority, now he opted for construction link plan, and he kept asking the builder for any sort of communication document so that he could go ahead and take a loan. But that did not happen. The builder kept delaying, yet he did not respond to his mayor's complaint. Nothing, and then later on, finally when it fit out later was sent to him by the owners, it was put on him, and now he is very worried about that, because there is a penalty that has been levied on him and for the delayed installments, and he says that it is not right. Moreover, he wants to know whether he will get any penalty from the builder, when the builder will pay any penalty to him or not. And he says that the project is not properly finished, it's of poor quality, he is being forced to register it. Now they also want a maintenance check, so he wants to know whether ERISI applicable here or not, and who should be turned to see him. So that luckily you booked this flight in Noida, and at this point of time nowadays, now the authority is very proactive against these kind of frauds, being cleared by the border. I would call it a fraud for the simple reason that you booked it as a bona fide consumer. He never shared any kind of documents, his construction plans and anything with you, and suddenly on top of it he is asking you for the money for the maintenance for a very shoddy quality of work. And he is saying that he is putting this conscious obligation of delay in the registry also on you, so that the address, all these things and our stuffs are very much clear. There are certain officers which have now been appointed by law authority who are listening between the builders and the bona fide consumers like you, and they are ensuring that all these builders are taken to task. So he is going to know the minimum amount that he is going to do, and he is going to pay. He is going to ensure that the construction is in order, and whatever amount he is paying or asking you to cough up will not be payable by you nor the authorities below. And ensure all of that. As far as RERA or RERA is applicable, you need to check whether the completion certificate and the occupation certificate is there by the builder. In case it's not there, then the reverie applicable, and if you come to know that they are applicable in this case, rest assured that the builder will have to do more to you as a bona fide customer or the consumer than you can even dream of at this point. Yes,